Right. Hi everyone, this is LAWS12066 land law, and this is a explanation clarification recording with regard to the 30% assessment. Look, I've had a couple of queries just on a couple of matters, and I thought it would be good just to give you the benefit of hearing me explain a few things about the assessment and what I'm looking for and what the expectations are, so that you're sort of on track in terms of what we're looking for and what the rationale behind the assessment is, put it like that. So that unlike the first assessment that had a technology component, and almost everyone has responded to that positively. I know there are a few technical issues with that in terms of logging onto the PECS website and so forth, but most students were able to satisfactorily complete that and commented quite positively on the experience and the value of that. This assignment is, I suppose, arguably a bit more conventional, but it still has potentially a technology component. So as you will have seen from the assessment, there are 3 questions for 30%. Each question is worth 10 marks. So it's a nice division, 3 questions, each worth 10 marks. You're given a word length indication there of about 850 words for each of the questions. And want you to try and stick to that word length, please. I've already said that my general approach is 10% either way is fine, but if it's excess and it looks like it's a bit, becoming prolix, then I will penalise that. I don't want you to use footnotes to try and get around the word length, long discursive footnotes. That's not the purpose of footnotes, but I'll just comment a bit more on that in a moment, particularly with regard to problem-solving questions. In light of what I've been seeing, for example, as I've been moving through the grading of the first assessment, just in terms of general problem solving. So just coming to the first question, it's fairly clear this is a policy style question. It's also clear that this relates to concepts that arise from topic 4 in the unit with regard to unregistered interests in Torrens land. There's also, you can see from the question there a link to e-conveyancing, and you can refer back to the materials that I've uploaded onto the Moodle website that have been supplied by PECSA, the slides, videos that will, give you information about what is possible in terms of the 2 mechanisms that are referred to in the question and how that works in the electronic conveyancing environment and through PECSA. The question is getting you to think about those mechanisms and to do that in the context of presenting your ideas to a meeting of the partners of the firm. And the point about the impact of electronic conveyancing is, well, how does that impact, how does that affect things? Does it change the way we understand these mechanisms? And will practice evolve and change into the future? So there's a sense of explaining the arrangements, there's a sense of discussing the differences, and also moving forward, looking prospectively, how will practice change? How should it change? I'm interested to hear what your thoughts are. I want to hear your voice. I want to hear your voice coming through the assessment. You might say, well, Michael, if I'm doing a podcast, there's no way you're not going to hear my voice. Well, that's absolutely true. And just getting on to that point. So this part of the assessment can be done as a podcast, audio recording, or a vidcast, video recording. And if you're doing this assessment as a group, right, and that's the whole of the assessment, not just question 1. If you choose to do it as a group, you need to do the whole of the assessment as a group. Then you see there that I've included information about the need for a verification of identity statement. It's not necessarily fully land title practice manual compliant, as you investigated in the first assignment. But it's just, the purpose here is, we're in the School of Business and Law, we're now focused on ensuring that where there is group work done, and we encourage group work because it provides opportunities for interactivity, sharing of ideas, working together collaboratively, which is what you will do ultimately when you move out into the world of practice and wherever your law degree takes you. We need, of course, from an assessment point of view, to ensure that there's involvement and participation by all members of the group. So that's the purpose of that. And if you are submitting as a group, then you need to include that. That can be a statement. It can be something that's signed by all of you if you wish to do that. That's not absolutely necessary. But and if you're choosing to do this part of the assessment as an audio or as a vidcast, then you can just have some statement there from each of you in the recording, and also the fact that I can see all of you or hear all of you in the recording. That's important, that you're all participating. So there's that method of verification. And even if you're doing this individually, I want to encourage you to think about doing it as a podcast or as a vidcast, because this is a presentation to the partners of the firm. And of course, if you were presenting in real life, and you may well be, it happens. It happened to me when I was a young lawyer. I was asked to present on areas of law and so forth to senior members of firms that I was involved in. Then you're not going to just present a document. You're not going to just circulate a piece of paper. They actually want you to talk about this, right? So I want you, all of my students in the unit, to think about taking up that opportunity. But as you can see, it's an option. So I understand that some folks prefer to do things as a document, and there might be some challenges around them doing it electronically with regard to recording an audio or a vidcast. So there is that. You still can do question 1 as a document, text-based document. But I want to encourage everyone to think about doing it as a short 10-minute podcast or vidcast. And if you're doing it as a group, then you'll have to choose that option. You can't just do a document. So that's question 1. It's a policy-style question as to getting you to think about this area of the unit and land law in terms of policy, practice, looking at procedural mechanisms, how they work in terms of protecting interests, and what are the practical implications in terms of, remember, you're presenting to the partners of a firm. I mean, they're practically minded individuals, right? And they're concerned about the firm, they're concerned about their clients, they're concerned about making sure that their legal practice is successful. So that, you need to think about that in terms of presenting. They're not just interested in an explanation of the legal arrangements and the legal framework. They are interested in that, of course, and you need to incorporate that in what you do, but be mindful of the audience you're presenting to, and that's part of the exercise in the assessment. Okay, so give thought to that. Now, look, I know we have students in the unit that have some experience in working in law firms. We have some that have never had an experience. I'm asking you to put yourself in the shoes of presenting to the partners of a law firm, and those partners, of course, are the people that are running the law practice, responsible for all of the lawyers, employed lawyers in the firm, and ultimately have obligations and duties to clients and wider to the interests of justice and so on and whatever in terms of their professional obligations. So be mindful of the audience that you're presenting to. Always in an assessment, be mindful of the audience. And in a policy style question, if you're being asked to focus on something or to deliver it to some particular group or whatever, that's an aspect of the assessment task, and you need to think about that in the way that you go about structuring the response to that particular question. Question 2 and question 3 are probably, arguably more conventional legal problem-solving questions, and I'm not going to go into the detail of those because that's for you to work on, but they relate to issues and concepts and law that comes out of topics 4 and 5, which is unregistered interests in the Torrens system and co-ownership. Okay, now it should be evident to you, which of those questions is dealing with which topics. All right. Couple of points by way of clarification, which I've mentioned to a couple of students. I had a query about whether or not which was it? Just let me check. Give me a moment. Right, so I had a query about whether in question 2, the facts justify a conclusion that one of the interests may have been registered. I think that should be sufficiently clear from the facts, but I think you can take it that we've had no registration of interests in this situation. But it's up to you as to how you interpret the implications of the facts in terms of what's transpiring between the parties. Had another question, a query with regard to question 3, and that related to the fact that there is information in regard to the renting out of rooms of the house that's referred to in the facts, but those occupants of those rooms have not been named. The fact that they haven't been named in the scenario doesn't mean that the rooms have not been rented. So you can take it that those rooms have been rented. You can assume that, even though the occupants have not actually been named. What I want to say generally about, I don't want to go into the detail of those questions because that's a matter for you, of course, and that's part of the task and the exercise. But what I do want to say is a couple of things just by way of general guidance with regard to problem solving, and in particular with regard to land law or property law type scenarios. First point I'd make is that, again, tight word limits on your responses here, 850 words. And I know some of you say, oh, Michael, that's not enough, not enough. There's a lot we can write, here. Yes, that is true. There is always a lot that one can write, but there are always limits on what we do as lawyers. And doesn't matter whether we're drafting up clauses, whether we're presenting arguments before a court, giving advice to a client, presenting to a meeting of partners. The key is to be succinct and to be as precise as one needs to be, and to be using the law and the legal framework skillfully in relation to the concepts or the ideas or the facts at hand. Now, of course, we need to benchmark in terms of referencing AGLC 4th edition. That's a requirement. A few variations on the theme I've noticed in the first assessment. So please make sure that your referencing is benchmarked against AGLC 4th edition, which is now the standard that we use. Given that tight word length, I've noticed that some students in the first assessment chose to just drop all of the legal authorities out into footnotes. Can I encourage all of you to think about the inclusion of selective legal authorities in the text of your answers, so that I can see that the law is being discussed and applied to the facts? I don't need a documentation of the law, but I need you to work with it skillfully and identify why you're referring to a particular law, and then, whether it be case legislation or case law, and then we need to see how that applies to the facts. And so we need to see that application. I need to see, obviously with a tight word length, you can't be, discussing, endless amount of law. I understand that, right? But selective identification of critical law in the body of your answer is actually more persuasive than dropping out everything to footnotes. Again, in terms of tight word length, always acceptable to use subheadings. You don't just have one long narrative, breaks it up. But you don't break it up in terms of facts, issue, law. No, we've moved beyond that, folks. Seriously, moved beyond that. We're just, what is the legal issue? Then have your discussion and your analysis around what you believe to be that legal issue in a more integrated way, okay? Working with the law in a selective way, in an appropriate way, given the parameters of the exercise, selectively choosing to talk about the facts, and then what is the outcome on that issue, and then move on, okay? In each of the scenarios, that's for question 2, and also question 3, you're being asked to advise or to provide advice, right? You need to think about that. You need to think about how does that impact on how you decide to present your response, okay? You also need to be mindful of what would that party be looking, what would that client be looking for, okay? Now, clearly you're not just serving up, what they want as an outcome. They need to know what the law is, of course, and that's the purpose of the exercise. But again, going back to my earlier point about audience, you are asked to advise a particular client in both of these questions. So make sure that's what you do, and make sure you don't leave everything juggling around in the end, because a client will not appreciate that. A client wants to know what your position is in your understanding and application of the law against the situation they've presented to you, and what do you think is the likely outcome. So I need to see what is your view about the likely outcome on the issues as you've identified them in the respective scenarios and questions, okay? So you need to think about how you're going to go about that process and how you're going to tackle it for those problem-solving questions. They're the sorts of features that I'm looking for in the way you go about the exercise. Problem-solving, of course, as we know, is a critical legal skill, but it's happening today, of course, in an environment that is very much infused with technology, as we know. One of the challenges of technology, I think, in this context of this type of skill, is it speeds up the process. And we need to remind ourselves that all good legal thinking, legal reflection, and legal writing requires some thoughtfulness, requires some attention to detail, and requires reconsidering what I've done rather than doing something, just doing it and then seeing it off. Right? There's a sense of how technology is speeding things up, and clients and others are wanting things from us in quick turnaround times. They can communicate with us from all different media and environments and apps, and on the go and not on the go, and 24/7, and we have to create an environment of what I want to call reasonably practicable expectations in the completion of our legal work. All right? Now, in the case of these questions, I've basically given you about 3.5 weeks to work on those. 3 questions, each worth 10 marks, just over 3.5 weeks. That's interesting, nice little balance there, isn't it? Yep. So what I want to say to you is spend appropriate time on them. Don't let it all run out to, to the last minute. It doesn't mean that you've got to tackle each one and knock them over. You can progressively work on things, and you'd be surprised how once you've started working on something, your intellectual ideas and thinking and getting your materials together start to form a shape before you get to the final version of what you want to ultimately submit. All right? And if you're doing this as a group, there are, of course, other issues and challenges and so forth in terms of collaborating and who does what, and want you to all to be involved in the totality of the exercise, of course. But that's just the nature of doing things in groups. And doing things in groups is, I know, and everyone identify this, that there are opportunities and potential for good experiences, building skills, and so on. Also, there can be challenges. I know that. Any group work, it can be challenging. I can tell you, I've worked in groups, I've co-authored projects. There are challenges, folks, there are. But that's the reality of how we function as lawyers. And we need to get that experience today, in my view, when we're in law school, so we have something as a basis in terms of how we understand how things work when we get out there in the real world. And I know some of you are already sort of, in a sense, in the real world in that way, in terms of involvement in legal firms and so on. But I think that your law school experience needs to capture and incorporate that as well. Just the other thing I want to touch on is legal materials and legal resources. Just remember, folks, that in land law, we have critical legislation. So we have the Land Title Act, which is the Torrens Act. We have the Property Law Act, which has had a substantial review undertaken. So if there's something in that review document that might be relevant in the context of the assessment, don't forget to have a look at that in terms of the topics that are referred to. You know, I'm not expected for you to go outside and beyond the topics, okay? In broader areas. These are focusing in on those areas of the unit that we've studied. And you've got that uploaded on the Moodle website, of course, as you know. But just always remember that particularly, you know, for both policy questions, but also problem-solving questions, we need your formulated outcomes, advice, proposals based on the current law. So I'm looking to see whether you're across the current law that has been made available to you. I'm not asking you to go and do huge amounts of extra research. You can do that, and that's encouraged, but not huge amounts. That's, you know, basically these problems and so forth can be undertaken against the framework of materials that I have provided to you. But there is materials that have more historical context. There's also more modern, more current legal materials, and I've tried to, you know, my aim has been to give you access to those both through the Moodle website and also through the printed materials, texts that are you know, very quite up to date. So there we go. Please submit your assessment as one document. That's helpful for marking purposes. The other thing is, I've had a query about if you do question one as a recording, can you just provide a link? Yes, absolutely. You don't have to upload the recording, you know, in terms of file sizes and so forth. Just provide me with the link. That's entirely acceptable. Explain where I find that. You use one of the conventional places so that it's not obscure and I don't have problems with software and so on. So that's fine. And then that's probably all. The other thing I'll just say is that I'll also plan to offer, like I did for the first assessment, a Q&A session on the assessment, just to deal with any final matters or queries. And I think it's probably most appropriate to offer that in week 7. So that's about midway in terms of the time that you've had access to the assessment, and it'll be about a week or so before it's due. So good luck with completing the 30% assessment. I hope you find it interesting and challenging. But at the end, you know, again, it's, from my point of view, it's something that wants to test a range of skills and understanding around the relevant areas in the unit, but that it's doable by everybody at the end of the day. It's something that I'm giving you the chance to do in groups, encourage that, and I'm also building in that technology component in terms of presenting ideas around policy and reform, sort of reform suggestions, if you like, as well as building critical problem-solving skills. Lastly, make sure, of course, as you refer to the rubric, which has now been uploaded to Moodle, in terms of guiding you through what, the sort of standards that apply in terms of how you go about the process at the end of the day. So there you go. There's an information and clarification presentation around the 30% assessment. And I look forward to receiving your assessments in due course. So, bye for now.